don't ever. That would work. I don't know. Sometimes it'll have a screen.
I don't know where it's the day I did it.
This is new.
Well, it's not showing us that long. You remember I called my duty? It won't just or you try. It'll just not try. It's on there. Well, it's not showing anything. Well, oh, so it's not showing the June payment. It wasn't that I was. Right, it's not pledging it. It's just. Yeah, see, I don't know. That's why I don't know when it'll go in. When they got called in, or I talked to you about, they gave you my account number. Remember, because we were gonna put it towards my deposit. Yeah. I honestly, I don't know what account it is. So, I don't know Monday. I have okay. I'm gonna sit right over here. Is it okay if I write my
Yeah, so I was kind
account
of
number?
wondering.
Yeah, just and write it on the back. Yeah, okay, be good. All right. These are really flush. Go inside over there, and then there's some. Okay, thanks. Go on my Facebook, go to mine, click on mine, see if it. Ooh, who's that? Wow, apparently I have a lot of people watching. Yep. Who aren't even in. They're probably like, what? You want me to monitor? Yes, please. And then share, I guess share the video so they can all watch it. Share it as Facebook. I guess. Share it right now. Yeah. All right, you can go and go. All right, I'm gonna introduce you.
Do we have a clicker for the PowerPoint?
It is. Oh, I'm gonna throw my shoes somewhere. In that little bag right there. Sorry, guys. Yeah. However, I don't know if it will work with.
Okay, so I
Hey. Let's see. It won't work because the drive that needs to be turned into it. Oh, there you go. You can do that. It only, our drive in the back only has two.
Am I doing that right?
USB ports. You got it. Yep. Okay.
All right, so that works.
Sorry, Dobson.
All right, so I'm Ashley Tatum. I'm in training with Ozark Opportunities for my story community, and I'm gonna introduce you to the presenter tonight. He's gonna talk to you about renters' rights and responsibilities, and his name is Corey Crawford. He is a housing attorney with Legal Aid.
Thank you. My name is Corey Crawford. I have been a staff attorney at Legal Aid now for 8 years. I've been in the housing worker for a little more than about a year. And today we're going to go over landlord-tenant law and also fair housing law and what to expect in Arkansas. I am at Legal Aid of Arkansas, so this will be coming from a tenant rights point of view. We do work on behalf of tenants and way more than landlords, so we are more pro-tenant. So this presentation will be a little more pro-tenant than landlord. So the global impact, this is from the book Evicted by Matthew Desmond. It came out about, I think, 2016 or 2017. It's a very good book, very informative. It goes into a lot of detail about the eviction process in Milwaukee, and goes through different stories with different tenants, different various landlords, and how they went and got about eviction, both legal and potentially illegal processes.
What happened in Milwaukee? Like they do something landlord tenant?
He was just doing a profile of landlord-tenant law in Milwaukee, and it just went into like several different individual stories. It's a really good book. So what's a tenancy? A tenancy is a possessory estate, and land is granted by permission of the landlord. So you're basically given possession of the land, or of the building, or of the apartment. A tenant has the right to use and enjoy the estate, and the right is protected by both the Arkansas and the United States Constitution. Tenancy is governed by the contract, which is the lease agreement, and contains promises by both landlord and tenant. A lease is always going to exist, but it could be written or oral. They are distinguished from other arrangements such as licensing or lodging agreements, or a purchaser in possession or a mortgage. So it's just for it is for just possessory right. It's not any kind of ownership right. Most obligations are going to be governed by the lease. In any dispute, look at the lease first. You always, if you're an attorney looking at leases, you want to look at the lease first before you make any determination of what to do further. But if you're the tenant, also look at your lease. Does it have an obligation by the landlord to do something, or is the obligation on you to do something? If the lease does govern in most instances, but there is illegal terms, penalty clauses, attempts to forego statutory protections or procedures. So this would be what's called self-obligation. We'll get to it a little bit later. A landlord can't just lock you out of the unit. They've got to go through an actual eviction procedure. An oral lease is valid, but it cannot exceed 1 year in length. If no term is specified, a lease is presumed to be month to month. It can be week to week if you're paying weekly, but for the majority it's going to be month to month, as much time you pay your rent on the first of the month. So security deposits is governed by Arkansas law. It cannot exceed more than 2 months' rent. It must be returned to the tenant within 60 days of the end of the tenancy. Generally, it's got to be returned to you, or an account of how to use that deposit to, let's say, fix things that might have been broken. So the landlord can withhold for damages that exceed normal wear and tear. So if you have carpets that are ripped up, they can replace the carpet with a security deposit, but they have to tell you after they use that money and how they used it, and they have to tell you that within 60 days as well. If the landlord wrongfully withholds the deposit, the tenant can be entitled to twice the amount of the deposit. That way, in that situation, you would go to court, basically take pictures of the unit, take pictures of the unit when you move in, and take pictures of the unit when you move out. And then you go to court and say, look, Your Honor, I didn't do any damage to the unit. They're withholding my deposit. I should get twice the deposit now. So tenant obligations. The Arkansas has a That's the Uniform Residential Tenant Act. Unfortunately, our legislator took out pretty much all the tenant protections. They kept all the landlord protections. Arkansas is considered by a few publications to be the worst state in the country to rent. And we'll get into why. So basically the tenant has the obligation to pay rent on time, keep the dwelling in a reasonably safe and clean environment, no ashes, no garbage, rubbish, or other waste left out. You've got to keep plumbing fixtures in the unit reasonably clean, no destroying, damaging, or removing any part of the unit, or knowingly allowing persons on the premises with the tenant's permission to do so, allowing persons on the premises without the landlord's permission, and not disturbing other tenants' peaceful enjoyment of the premises. The landlord's obligation, comply with security deposit law and abide by the Fair Housing Act. That's pretty much it. In most other states, there are quite a few other landlord obligations. Arkansas did not provide those.
Does that go for maintenance on the unit and stuff? Obligations for the working, the person who's renting?
I guess on the past two things, you said that the landlord's obligated to do.
Yeah. Are they not obligated to maintain?
Unless it's in the lease, no. If it's in the lease, they are, but if it's not in the lease, they have no obligation to maintain
their own
fixtures.
property?
Yeah. And even worse, we don't have what's called warranty of habitability. I believe that's coming up later, but warranty of habitability would be the place is safe and habitable. All other states in the country have that, we don't. So this means, the roof is actually working, there's no leaks. Air conditioner's working, heater's working in the winter. No black mold, stuff like that in other states would cause the landlord to actually fix those things. In Arkansas, they have no duty to fix.
So when it comes to like housing and HUD, they have a bit more of a list, list there, so that's good for us.
Right, yeah, but public housing is gonna have restrictions, they have to pass. So even section 8 and public housing, section 8, they've gotta go through inspections.
Right, yeah, they have a list of
Yeah.
things.
So in the eviction process, there's 4 things, 4 ways to go about it. One's definitely legal, one's probably unconstitutional, one is most likely unconstitutional, and the other one is absolutely illegal. So unlawful detainer is the legal version. Then this is the most common method of eviction in Arkansas. So you get 3 days written notice for non-payment of rent, 14-day notice with opportunity to cure for anything else. Although this hasn't necessarily been tested, this is what the law says, so we gotta go with it, but there's some confusion there. Notice must be given in a way that's reasonably calculated to get to the tenant. Most likely, if it's not handed to the tenant, it'll be posted on their door, but it's gotta be, some way the tenant's gonna get it. If the tenant does not vacate by the end of the notice period, landlord files a lawsuit in circuit court, $165 is the filing fee. Once served with a lawsuit, the tenant, and that's got to be by service, so that's going to be actually getting to you by process server or sheriff or by certified letter that you sign for. But once you've been served, you have 5 days to file a written objection with the circuit clerk. You send that objection to the opposing attorney, and you object to the possession and answer the lawsuit. At the time of objection, the tenant must also pay into the court registry the amount that the landlord alleges owed in rent. And now this requirement, in parentheses, this requirement is likely unconstitutional. If you are going to challenge the eviction, we still advise to go ahead and pay into the registry. Let's not, just to make sure you have that defense. If the tenant does not properly object and pay, the court can automatically issue a writ of possession. That means that a sheriff will come to your door and say, please get out, and we'll help you get your stuff out. Not necessarily help you, they will get your stuff out. If the tenant does object, if the tenant does object and pay, the matter is going to be set for a hearing, usually pretty quickly. You're probably going to get a hearing within a week or two, depending on where you are, depending on how your court is set up sometimes, so if court doesn't have civil days, but once a month, you may get a full month, but generally it's gonna be pretty quick. It is a bifurcated hearing process. That means there's gonna be 2 hearings. The first one and usually the one that's gonna be set real quick is gonna be the possession hearing. That's literally who's gonna get to have the unit as the the lawsuit goes forward. So, if the judge thinks that the landlord does not have the right to evict, you get to stay in the unit until the actual final hearing. If the landlord believes that the grounds for eviction are correct and true, then you will lose the unit until the final hearing, unless you pay into the registry an amount that the judge can come up with, and you can stay until the final hearing. And the final hearing will be on damages. So that'll be on, rent owed, or damage of the apartment, or if you're the defendant, you can get damages for, things that the landlord failed to do, and that's why if you added some defense to the eviction. The bonds are required by both landlord and tenant, so that's money paid to the registry to prevent, to basically have your case heard. And the damages can be actual damages, so damage to the unit, rent, unpaid rent, liquidated damages, which would be damages that are put in the contract. So if your contract says, if you get evicted, you also owe another month's rent, that's what's called liquidated damages. Costs and attorney's fees. If the tenant wins, they can get damages. They can also get rid of rent restitution. That just means that you're allowed back in the unit. And the final hearing may be tried by a jury. The district court civil process, this one's probably unconstitutional. We don't see it in a lot of places. It's happening in a couple of cities. It's a lot like the pre-possession, but it's a different court. So it's a 5-day notice for non-payment, 14-day for anything else. Then there's a 10-day order to show cause. It does not provide for damages. It's only a possession hearing. There is a jurisdictional issue. The Supreme Court does not give jurisdiction to the district court. So the district courts are the smaller or the lower courts. The circuit courts are the bigger courts. So the Supreme Court of Arkansas gives jurisdiction to each court of what they can hear. And the Supreme Court hasn't given the district court jurisdiction to hear these. No one's tried that. No one's argued that in front of the Supreme Court, so no one's actually had any. We don't have a clear answer if whether this is or not. Most likely it's not constitutional, but again, not a lot of courts are seeing these. But again, no damages. This is just possession. So this is literally just getting you out of the unit. It's heavily used in some places. I'm not sure about Harrison. I don't know if it is or not.
You have like renter's insurance. Is that is eviction covered under renter's insurance?
No, renter's insurance is more if a flood happens or a fire or something like that. Yeah.
Okay.
Criminal eviction, we are the only state that criminalizes non-payment of rent. This is Human Rights Watch took a break from going to Rwanda and Syria and came to Arkansas and said, yeah, this is real bad. 10-day written notice required. If you're late in rent, this is only for unpaid rent. You can't be criminally evicted for damaging a window or having too many unauthorized guests. This is literally just non-payment of rent. But you have 10-day written notice required, so you're basically told get out or pay your rent. If you don't, there's a fine of $1 to $25 per day. Again, this is not an actual eviction statute. This is just a punishment statute. If you don't pay your rent and don't get out, you're charged that per day, but you're not actually evicted. The court has no right to get you out of the unit.
It's spelled right with a W of possession? That last bullet?
Writ of possession.
Oh.
So a writ is a judicial order.
Okay.
And there are serious constitutional issues with this. 4 courts have found that the current statute is unconstitutional based on due process, right to trial, calling it a debtor's prison. We've litigated it in several counties. So 13 counties currently have it as unconstitutional, and many other counties refuse to enforce it. So landlords may go to the prosecutor and say, hey, I want to file a criminal eviction, and the prosecutor refuses. Um, There were amendments in 2017 to fix some of the issues, but a lot of the counties that were told that made it unconstitutional have not reintegrated the process, so it's still not being done. This is a map of where it is used and not used. You can see that it's not being used in Boone County, so it's not being used in Harrison. It is being used a little bit in Springdale. And the red is where it's considered unconstitutional, and it definitely is not being used. So the entire Delta and then Pulaski County, it's not being used, but there's still giant swaths of the state that it is being used, so anything in green is being used. And those are the legal to potentially unconstitutional ways of getting out. Self-help eviction is the illegal way. So changing locks, cutting power, cutting out water, taking out heat and air, threats by physical violence, use of bodyguards. We had a case in Paragould where the landlord went to a unit and told the person that this is their eviction notice, or that they're being evicted. They said, we never got a notice. So he went back to his car, got the gun out, said, this is your notice. And then with his wife there and son said to his, we guess, bodyguard, I think I'm going to go coon hunting. It was an African-American man, and that cost him quite a bit of money when he lost that court. This is illegal. Don't do it. It's called forcible entry and detainer. You can get a tenant who suffers a self-help eviction can get damages, liquidated damages. They can sue for tort, because on that case, we were able to sue for emotional distress. We sued for harassment, assault, quite a few things that we were able to get, and won a pretty substantial case there. Breaking the lease before it's actually done, before it expires. In Arkansas, it's pretty difficult as a tenant. Usually it requires some negotiation, and if you do get a release, get it in writing. Don't rely on the landlord to say, yeah, it's fine, go ahead and leave. Make sure that it's in writing. Constructive eviction, if the housing conditions are so awful that you cannot live there anymore, you can tell the tenant, again in writing, that I am not paying any more rent, I am leaving. Now this, it takes quite a bit of problems to actually get this. So there's like a hole in the roof, giant flood in the unit. That's the kind of thing that will lead to constructive eviction. The fridge isn't working, the washer and dryer isn't working, that's not going to get you to constructive eviction. It's going to be serious things that make it unmovable. Now abandonment, so if you abandon the place, you just up and leave property behind, the landlord has statute approval to just take the property and sell it. And the breaking lease again, so landlord has three options to break the lease. They can let the property sit empty and sue for rent as it becomes due. So they have no obligation to actually re-rent the unit. They can just let it sit and then sue you for the amount of damages that you left. They can retake the property and use it themselves. That cuts off the ability to sue. Or they can re-rent the property and credit the rent received to the previous tenant's account. So if you leave on May 15th and they re-rent the unit on June 1st, they might not have any damage against you, because June 1st would have been the next payment of rent. The only way they would have damage is if they have to make a liquidated damages clause, and they would be able to do that. Also, if they rent the property at a higher rate than they're renting you, you would actually be due a surplus. If they rent a lower rate, you would be liable for the amount that they were under.
Like if they rented it for more than what you're paying?
Yeah, so if you're renting for $450 and they rent it for $500, now, that's only if they got something, yeah. And that gets cut off if they have a liquidated damages clause. And special damages, so cost of re-renting is also available. So if it took them several $100s to re-rent the place, they had to like do some cleaning, or they had to advertise in a newspaper, so that can also be used as damages that you have to pay for. Domestic abuse protections. So Arkansas does do a little bit to protect victims of domestic violence. They were added to the code in 2007. It is basically, there's a few things that you're allowed to do. You're allowed to change the locks with, it's going to be charged to you as the victim. You're going to have to pay for the lock change, but all you have to do is change the locks and give the key to the landlord. You are allowed to get the abuser off the lease, but the failed revision in 2019, unfortunately, did not allow a domestic abuse victim to leave the unit and without basically breaking the lease. So what they were trying to do is allow a victim of domestic abuse to leave the unit and leave the lease without being liable for damages, but that failed. So if you do leave the unit, even if you are a domestic abuse victim, you're still going to be liable for any damages for not payment of rent.
That's like another can of worms you could talk about.
So, and this is again, so when there has been documented incident of domestic abuse, so if there's a protection order in place or a no contact order from a criminal case in place, a landlord can't terminate the lease, they can't fail to renew a lease, and they can't refuse to enter into a lease, and no retaliation based on the domestic abuse. So we see usually that occurs. You see the landlord say, you know, the police were called 3 times in a month, we're going to evict you because of that. If those police were called for domestic abuse, that's not a valid reason for an eviction. And a landlord or tenant, other than the offender, may change the locks of the residence, again, at tenant's expense, with the landlord's consent, and the landlord and the copy of the key should be furnished to both parties.
So if they're a member of or if they're the person that had the domestic violence done to them, do they have to pay for the locks to be changed?
Yes, landlords can require them to. Landlord volunteers to pay, that's fine too. But if the domestic abuser is ordered by the court to stay away from the survivor's residence, the offender may enter the residence only to extent permitted by court order. Usually this is going to be with a sheriff present or a police officer present. And a landlord may refuse access by the offender unless access is permitted by court order. And the landlord may pursue legal remedies against the offender, including terminating the lease, evicting the offender, even if he's on the lease, and then bringing an action in the court to terminate the lease as it pertains to the offender. And they can also obtain damages caused by the offender. So that was landlord-tenant law. Now we're going to fair housing law. Fair Housing Fair Housing Act was established in 1968, days after the assassination of Martin Luther King Jr. It's broader than the Civil Rights Act that was previously enacted, because that was only dealt with racial discrimination. But now the FHA covers race, color, national origin, sex discrimination, handicap, familial status, and disability. So race is pretty cut and dry. You cannot treat someone unfavorably because of their race or personal characteristics associated with their race. Same thing with color, although color does a lot very similar to race, but you can also it also depends on the tone of their skin. So you can't discriminate someone because they're lighter skin, Asian instead of darker skin race. Religion, again, pretty obvious. You can't treat someone unfairly because of their religious observance, practices, or beliefs. National origin involves treating someone unfairly because of their place of origin or ancestry, or because the person has physical, cultural, or linguistic characteristics of a particular national origin. So sex is a little bit more encompassing. It involves treating a person unfavorably because of gender, Harassment is included in sex discrimination. So, deliberate sexual harassment is deliberate and repeated unsolicited verbal comments, gestures, or physical contact, creating a hostile environment or when sexual favors are sought in return for housing, which is called quid pro quo. So a landlord can't say, if you do something for me, I'll, lower your security deposit or something along those lines. That's automatic fair housing violation. Also, sexual harassment can involve other tenants and the landlord can be held responsible for the tenant's behaviors if the landlord refuses and fails over a period of time to protect the tenant from that harassment. So if a tenant says, hey, my neighbor continually wolf whistles at me and continually says derogatory things, continually says this, and it happens over and over, and the landlord does nothing about it, gives no warnings, gives no inclination that he's going to have any kind of eviction process because of that behavior, the landlord can eventually be put on the hook for damages caused by the tenant. But it would have to be a lot more than one incident. For sexual orientation, HUD assisted housing and FHA loans, there is a definition for sexual orientation, and there are some protections to sexual orientation as well. And again, I was already talked about quid pro quo, and a hostile environment is based on a reasonable person in that tenant's position considers it hostile.
Is that from like a case, quid pro quo?
Yes, it's just Latin, something for something.
You know how some things are like royalties or security because of certain lawsuits?
Yeah.
So that's what I was asking.
So familial status is treating someone unfairly because of children, pregnancy, or adoption. So like occupancy standards must be reasonable. So this would be, how many big persons per room we can lease a unit at. Someone says, you can't have more than one person per room, that's going to be a violation of familial status. Usually you're going to have two people per room is going to be considered somewhat reasonable. We can make it a little bit more than that. HUD considers the number and size of bedrooms and other special circumstances. Burden will be on the occupancy standard creator to establish reasonability. So it's going to be up to the landlord to show that it's reasonable that a unit only can have one person or two people in it.
So does that include, like boyfriend and girlfriend living together if they're not married?
Yes. Yeah.
That includes that, because we have a lot of people around here that will say if you're not married, you can't live here.
Yes, you're very likely in deep trouble there. And families, and this is another big one, families with children cannot be segregated from other families. So you can't direct a family with kids to one building and have another building with no kids. If a family wants one building and there's no reason to prevent them from that building, they should be able to get that building. And the reason there's no room in that building.
And you can also, Corey, just to hop in, that can also be like an upstairs unit. They can't say no children, no families with children on the upstairs unit.
Yes.
Only downstairs unit. They're not allowed to do that either.
So, some landlords may say, oh, we only have children on the second floor. They're going to run around and cause noise on the first floor. That's not allowed under the Fair Housing Act. A unit that's available to a family without children is available to a family with children. Disability involves treating the person unfairly because of their physical or mental disability. Disability can include a failure to properly design and construct a dwelling in a manner consistent with ADA or Fair Housing Act design standards, which would allow a person with a physical disability to enjoy the full use and benefit of the property. And handicap is any physical or mental impairment which substantially limits one or more of such person's major life's activities. A record of having such an impairment or being regarded as having such an impairment. And the only caveat is addiction to a substance, to an illegal substance or controlled substance is not considered disability. Now, and such major life activities is can't feed themselves, can't clothe themselves, can't wash themselves, but also, it has maybe limited mobility, limited thinking capacity, Also anxiety, PTSD, a lot of mental impairments that may not manifest themselves as easily as physical. So the FHA covers all dwellings unless it's an owner-occupied dwelling with 4 or fewer units, or a single-family homeowner, or a home owned by an owner who owns fewer than 4 units. Dwellings are defined as any building, structure, or portion thereof which is occupied as or designed or intended for occupancy as a residence. This means public housing, homeless shelters, long-term hotels, and nursing homes are all considered dwellings for purposes of FHA. Some of the buildings you think might be under Fair Housing Act, they will be considered Fair Housing Act buildings, so mainly the homeless shelters and the long residency hotels.
What about like homes that rent out rooms? That wouldn't be covered, right?
Well, it depends if there's more than 4 units that they would be.
Oh, okay, it's like a super large house.
Yeah.
More than
The Act recognizes 2 types of discrimination, discriminatory treatment and disparate impact. Treatment is overt discrimination. That's the one you're going to see a lot more often. It's a lot easier to show than disparate impact. Disparate impact is going to take a lot of, basically it's a lot of math. So prohibited conduct is it's a refusal to rent, sell, or make housing available. Discriminate in terms, conditions, privileges for sale or rental. Discriminatory statements or advertising. False representation of unavailability. Blockbusting and disability. So blockbusting is it's basically advertising that this neighborhood's going badly. You want to get rid of your house right now because a certain race is coming in. So we're going to try to change the racial makeup of the unit and basically sell for a higher price or lower price. And for false representation of unavailability, how you do that usually is what we do is testing. Our testing coordinator is Ms. Lancaster. We call landlords and have someone act as a person who's looking for a unit for his family of 4 and see if that unit's available and ask, and then have someone call about an hour later who's looking for a unit for himself and his wife. And if they say no unit's available for children, but unit's available for without children, they're likely a violation. We'll do the same thing with racial discrimination, same thing with disability discrimination. We test for all kinds of
That blockbusting, isn't that defamation of character? Yeah, no.
No, blockbusting is advertising. There's nothing to do with.
It's still defamation of character. It's putting somebody's self under discrimination. It's putting them down.
Well, it's not putting anybody down. You're saying that what you're going to someone's house and saying there's a certain group of people coming in.
But it's your opinion about them.
No. It's not your opinion about anybody. You're lying to someone basically. You're saying, hey, there's a group of people coming in. Your house is going to be worth a lot less money if you sit in it. So we will buy your house for you at this price, but they're not actually. They're all they're doing you out of assets. Fair equal lending is also protected. So violations include imposing a higher interest rate because of race, maybe making loans to blacks for homes in not making loans to blacks for homes in majority white neighborhoods, taking a longer time to process a loan because of borrower's race, redlining and then reverse redlining. And that is basically, redlining is refusing to make loans to people of a certain race because you don't believe they have equal for any reason really. And reverse redlining, so basically you make loans so basically egregious that they can't possibly pay them back in certain areas. So if it's like an area that's predominantly black, you're going to have loans that have a very high interest rate or have require a high down payment. So also threats, intimidation, and coercion are prohibited. Graffiti written on or about an individual's property, vandalism or violence against an individual or their home, such as firebombing or cross burning, retaliatory conduct against an agent who will not discriminate against prospective home seekers because of class membership at the direction of the employer. So that's more likely for your, so if you have a realtor and an agent refuses to go by a realtor's policy, the agent can actually sue if he's retaliated against for not going against a fair housing violation policy. So filing a complaint, individuals can file an FHA complaint with HUD or the Arkansas Fair Housing Commission. You have a 1-year statute of limitations, so if you believe there's been a Fair Housing Act violation, you have 1 year from when that violation occurred to make a complaint with HUD or the Fair Housing Commission. The Fair Housing Commission and HUD have 100 days to investigate and come up with a finding. You can also file your own private lawsuit. You have 2 years from the date of the violation. And then for the type of relief, you can get compensatory or punitive damages. Compensatory damages are damages that you actually incurred. Lost rent, lost property, that can be compensatory damages. Punitive damages are punishment damages. So that's to punish the landlord or the realtor for actually violating the law. And then you have reasonable attorney's fees. These can be quite excessive. Not excessive, reasonable, but they actually can go by how much the attorney worked. Court costs, so if you had to pay a filing fee or had to pay for a deposition or something like that, you can get that money back. And then you can also get injunctions. You can get a court to actually direct a landlord to stop that practice or direct a realtor to stop that practice. So reasonable accommodation, this is for persons with disability. Reasonable accommodation is a change in a rule, policy, practice, or service that may be necessary to allow a person with a disability to equal opportunity to use and enjoy the dwelling. So what you do is you follow this little equation here. Necessary and reasonable, and the housing, if the reasonable accommodation is necessary and reasonable, the housing provider must grant the accommodation. The requests can be oral, but usually you should write them down. That way you have covered for if you need to actually file a suit or file a complaint with the commission. If possible, it's always best to make them writing. Doing so is not necessary. Reasonable accommodation process begins once the tenant tells the housing provider that they are disabled and need something changed in order to accommodate that disability. If the disability is not apparent, the landlord can ask for proof. A lot of times you see this with like someone has anxiety, they might require the doctor that says, hey, this person would benefit from having an animal because they have anxiety and an animal services that disability.
I kind of saw one where a lady needed an extra room to exercise in because of her fibromyalgia or something like that.
That would be a reasonable accommodation request, and they would probably, fibromyalgia probably is not readily apparent, so they probably require doctor note, or a landlord can require doctor's note. If the disability is apparent, you can't ask them about it. So if a person comes in and they're clearly blind, they have a saying hi dog, you can't ask them to give proof that you're blind. If they're in a wheelchair and they obviously can't move, you can't ask for accommodation, you can't ask for a doctor's note to say why do you need a first floor unit. So there must be a nexus between the disability and the request accommodation. There has to be it has to make sense. What you need has to actually service the disability. So, if you're in a wheelchair, obviously a first floor apartment, that has a nexus.
I have a question. Okay, say I've been checking around at different places to rent here lately, and there was a place here in town that said that they would do service dogs, but not emotional support animals.
Under the Fair Housing Act, there is no difference between a service animal and emotional support animal. So that would be a violation if they do not allow emotional support animals.
Okay.
The Fair Housing Act basically considers that a service animal. I mean, not service animal in English. They're defined, but they're not differentiated in the Act. There we go. A landlord must provide a requested accommodation unless the landlord can show that doing so will impose an undue burden or result in fundamental alteration in the service provided by the landlord. So an undue burden would be something that is just so out of the realm of possibility as far as like expense. So say someone has PTSD and they request, and you know they're loud noises or security is their main concern. Maybe a security camera may be a reasonable accommodation. 24/7 security outside their door probably isn't. So it's got to be something that is not going to be prohibitively costly. The fundamental alteration, if a landlord isn't providing a service generally, they're not going to be required to provide a separate service for reasonable accommodation. So if someone says, you know, I really need someone to go pick up my groceries every week, a landlord's not going to be required to do that if they're not already doing it for other people.
Would it be a discrimination if they had two potential tenants and one had a reasonable accommodation and the other didn't, for them to have chosen the other one? You know, what am I trying to ask for here? You couldn't really prove that they did that.
Yeah, you know, I mean, you'd have a proof issue. I mean, if they came out and said, no, we're not going to rent to you because you have this, I mean, yes, I'd go ahead and sue on
Just
that.
feel so
Or if they said, you know, if the person with the reasonable accommodation came in first and they said, no, we don't have anything available, and then they said to the other person that they do, then you would have to be able to prove it, but that's what testing would do.
Yeah.
So yes, it would be a violation, but it would be hard to prove it.
Yeah.
Right.
If they both came in on the same day and we don't have an hour stamp on anything, we're not going to have any idea of who came in first.
It's
But
like this in the
right.
air.
But an application says, you know, 7/11/2019, and the one that didn't have any issue has 7/12/2019, and they pick the person without the disability, you might have a chance. Anyway, and the need for an accommodation may arise for any time. So you can bring up a reasonable accommodation when applying. You can bring it in the middle of the tenancy, and you can even bring it while you're trying to avoid an eviction. So it doesn't matter when you bring it. You just got to make it known to the provider. Now, reasonable modifications. A provider must permit, at the expense of the person with a disability, a reasonable modification of existing premises occupied by such a person, if the modification are necessary to allow the person full enjoyment of the premises. So this is, you know, grab bars if someone has got a physical disability or so they're usually something along those lines, grab bars like that. If the housing is federally funded, it is the owner's responsibility to pay for reasonable modification and not the tenants. And that goes through what we've had. I'm not fixing an hour, but I have. I can give a card. I think I've got my card here, but.
And Jason can answer your questions too.
And Jason can answer questions as well. And Jason, our worker leader, he has as much knowledge as possible. Any questions?
I live in a trailer park, and we have trees there that we're not allowed to call tree service to have them taken down, because if a tree falls, then we've been told that it's our landlord's supposed to be responsible for that, unless we are the one that's taking care of them. But yet, we can't call the tree service and have it taken care of and pay for it ourselves, because, you know, and if something falls, a tree falls during a storm or something, we're supposed to have this insurance on our vehicles, you know what I mean, to take care of it. Why is it like that way?
I mean, it's going to be up to your lease at all points. I mean,
Our lease doesn't say anything about that, except for our living, where we live, we take care of our conditions around here. Doesn't say anything about trees, so what if a tree falls on our vehicle? Is that, with renter's insurance or something like that?
I mean, renter's insurance would
I mean,
likely
we have
cover
to get
that.
that.
That's going to be up to a renter's insurance policy and covering things that are outside.
Okay, what if you don't have renter's insurance, then whose responsibility are the trees that you live in a trailer park? The landlord? Do you sue the landlord if tree falls on your vehicle or your house or your trailer?
Well, you're going to have proof issues on that. If you're going to have to show that a landlord was actually negligent in not cutting back the trees. So if it's a big storm and a tree looked like it had no issues with it and it knocks over a limb, they're likely not gonna be held responsible for it. If people have been telling the landlord, over
Like
and
a
over.
tree's rotting at the bottom, it has.
And they've been told many times, you're gonna have, especially if you do it right, you're gonna have a better claim if that happens. But it's still gonna be, it's a question of liability, and it's gonna be kind of hard to figure out. Your car insurance will probably cover some of it if you have more than liability, but.
Man, look at that. Wow, good job.
Any other questions about
I was also, on renter's insurance. Now, I have heard that if you have renter's insurance, it goes to your landlord. Or does that go back to you if you file a claim?
It depends on what is being claimed. So say there's a fire that you caused or anybody caused and it burns up your stuff, you should have, the renter's insurance should cover what you have as far as what your property is damaged, but it'll also protect you for any liability that if you cause it for the landlord, if he tries to sue you for damage you did to it. So it depends basically depends on what insurance you get. Renter's insurance can be, you can get a lot of things.
Right.
You can claim, you can try to get up to $15,000 or whatever to your personal property and you cover $100,000 to any damage you may cause. So that money would go to the landlord, but you would also get money to cover the stuff with the damage in your unit. Any other questions?
So I had an aunt who had a landlord who told her that she couldn't have men visiting, period.
But my landlord told me, no, but then no boyfriend or you, because you're not gonna be allowed to have a boyfriend. It's like
Not
married
stay the night,
anyway.
but visiting, like no male.
Yeah, that's gonna, very likely you've got a couple of violations with that. You're gonna probably have a familial status violation. You could also argue sex discrimination by itself. But yeah, that landlord, I mean, you have
What if they were family members, your brother, your dad, your grandma, or?
Anytime her son would come over, he lived very close and he could see a man was there and he'd show up.
Yeah.
Until he realized it was the son and
It'd be okay with the
Yeah.
son being there.
but I mean, he wanted to know every time.
I would, yeah, that's very likely a violation.
I witnessed it a couple of times.
So she was supposed to call and ask permission for her son to visit, or?
She just never did because she was like.
Yeah.
Well, that was very informative. I mean, I learned a lot. I'm like looking for a house to rent right now and stuff, so it's like right on point.
I just moved into a place, I'm so excited.
Yay, I'm excited for you.
You guys should really do some testing in this area.
We have a fair housing project that we actually are working on. We're doing a lot of testing and a lot of litigation. So I'm the testing coordinator and I am looking for people, or we're the only people doing testing in the state. So, yeah, if you hear anybody discriminating, you're welcome to reach